This is the Chapter 40 video recap for the legal environment of business law. And as you are aware, we're talking about various business entities from sole proprietorships to partnerships to limited liability companies, and now we're talking about corporations. And specifically in this particular chapter, we're going to be talking about the rights and responsibilities of the three groups that comprise a corporation: the shareholders, the board of directors, and the officers of the corporation. Let's see if we can break this down here. Moving on, talking about directors and officers. Well, let's see. Speaking of directors, directors are elected once the corporation is formed, and directors are elected by the shareholders. And they're usually described in the bylaws how often the directors are elected, and the process for electing those directors on the part of the shareholders. Directors may be removed for cause if they engage in naughty behavior, or if they become incapacitated, or if they die, or they can be voted out by the shareholders whenever it comes time for them to come up as a potential director. So those are the different ways they can come and go. Traditionally, directors were not compensated. They did not receive any salary for their services. However, more recently, because of how technical and the expertise that's required to be a director, directors are usually given some type of an honorarium or a salary for those services. There's also a difference between an inside director and an outside director. An inside director also is usually a shareholder of the corporation. An outside director is somebody they bring in from the outside, like a Dick Cheney or a Condoleezza Rice or some other big heavy hitter to add prestige to the corporation by that person serving on the board. Whenever there's a meeting, in order for the meeting to be legit, you have to have a certain number of directors present that's called for in the bylaws of the corporation. And depending upon what they vote for, voting will be either a simple majority, or if it deals with a major business decision of the company, affecting the company, it may require greater than a majority to vote. Directors usually form various committees to meet and to make decisions in between the times that the directors meet. At the very least, there's going to be an executive committee and an audit committee that serves in those respective capacities. When it comes to the rights of a director, they have the right, of course, to participate in the grand vision in the dealing of the corporation the way the directors do. Just by way of review, again, the directors deal with the big vision, the big picture of the corporation, whereas the officers who were employed and hired by the directors deal with the day-to-day business of the corporation. So the directors have the right to participate. They have the right to inspect the company records to make sure everything is being done the way it should. And they have the right to what's known as indemnification. That is to say, if the director gets sued by someone outside the corporation agrees to pay their attorney's fee, the director's attorney's fees, and to indemnify them. That is to cover whatever liability may exist, assuming the director was not engaged in some type of bad behavior or did a breach of duty of due care. So, but you can understand the need for indemnification, because if we didn't cover their butts, nobody would want to serve as a director in the first place. So anyway, when we're talking about corporate officers as opposed to directors, again, the officers are hired by the directors. You'll have a president, a vice president, any number of vice presidents, a treasurer, secretary. They act as agents of the corporation. And if you look on page 762, it gives you a nice overview of the summary of the rights and duties of both directors and shareholders. Moving on. Directors and officers. Well, both directors and officers have a duty of care, and we've talked about that before, as well as a duty of loyalty. And that's spelled out. The duty of care is spelled out in the PowerPoint outline there. When it comes to making the right decision and whether or not an officer or a director did make the right decision, the courts use what's known as the business judgment rule. And basically it says if the person in the corporation took reasonable steps, did their homework before making this decision, if they walked into it with eyes wide open and were fully informed, they had a rational basis for that decision, there was no conflict of interest, then the courts will say, okay, based upon the business judgment rule, we're not going to hold that person responsible, even though the results of the decision went south, which makes perfect sense because, again, who would want to serve as a director or an officer of the corporation if every decision they made, if any decision went bad, they could be held personally responsible for it or be in trouble for it by a plaintiff. So the business judgment rule helps protect these people who work for the corporations, assuming the criteria has been met, that they did their homework, walked into it with eyes wide open, and had a rational basis for whatever choice they made. It's a good rule. Duty of loyalty. So we talked about the duty of care. Okay, now there's a duty of loyalty with regard to directors and officers. Again, you work for the corporation, you make decisions that are in the best interest of the corporation, you don't engage in self-dealing, you don't take advantage of a corporate opportunity for yourself, you don't do conflicts of interest or pursue things like that, you don't use inside information to benefit you personally. You don't authorize an action that might be detrimental to a minority shareholder. Things like that. You work for the corporation. You're looking out for the best interests of the corporation and for the people who are in that corporation. And if there's any conflict of interest, you need to address that. You need to disclose that. So that's what the duties are. When it comes to liabilities of directors or officers, as we talked about previously, liabilities, there can be personal liability. There can be if they act while working as a shareholder, as a director or an officer, and while in the scope of their role, they make a mistake, they do something bad, it could mean trouble for them. So there is potential liability there, and which is why we have, especially when it comes to directors, indemnification, and sometimes with officers as well. Role of shareholders. Shareholders are the people who invest in the corporation. They buy the shares. They have no responsibility for the day-to-day management of the corporation. They're passive investors, but they do have the power to amend the articles or bylaws of the corporation. They do have the power to elect and remove members of the board of directors. And some shareholders have the power to vote at the shareholder meetings, which is kind of a big deal. You show up at the shareholder meeting and you vote on various big things that shareholders can vote on. When the shareholder meeting exists, the shareholders are notified. They can choose to show up and vote, or they can choose to provide their voting right to somebody else in the form of a proxy, someone to vote on their behalf. Shareholders' proposals are reviewed and voted on, and there's also rules for proxies that are involved usually at all shareholder meetings as well. Shareholders, when it comes to voting, a certain number of shareholders or shares have to be present and represented in order for voting to take place. And there's also a concept that's known as cumulative voting. We discussed that in class. There's a chart on page 770 that explains it very well. Essentially, it gives the minority shareholders a chance to elect at least one director through the process of cumulative voting. And you'll see how it makes sense on paper when you do the math. Rights of shareholders. They have the right to vote depending upon their shares. They have an ownership share in the corporation. Sometimes they have preemptive rights. If there's more shares that are being issued, a shareholder with preemptive rights has the right to buy more shares, to be first in line to do that so they can maintain their percentage of ownership in the company. They have sometimes stock warrants, the right to buy shares at a designated price by a specific date. Oh, that's a great thing, because if the value of the stock shoots up and you sit on it, a year later you can buy stock for an extremely discounted price if it's worth a lot more because you have that stock warrant. You're entitled to dividends as a shareholder when the dividends are declared, but the dividends have to be legal dividends. There has to be money in the corporation to make that dividend. Sometimes if the directors fail to declare a dividend, the shareholders can force their hand and say, look, you're sitting on all this money, on all this retained earnings, you should declare a dividend, and they might be able to get, as shareholders, a court order directing the directors to declare and issue a dividend. As shareholders, they have rights to inspection, to review the records. They can, if it's a publicly held corporation, they can transfer their shares. If it's a closed corporation, probably not. They have to be bought out as shareholders. Sometimes the shareholders can bring a derivative suit to force the directors into action or to take certain steps. And if any amount is awarded in that derivative suit, it's not awarded to the shareholders, it's awarded to the corporation. Duties and liabilities of shareholders are very straightforward. Their liability is limited to the dollar amount of their investment. Unless they're engaged in active management of the corporation. We talked about alter ego in a previous segment. We'll cover that. There's also a duty of majority shareholders to minority shareholders, though not talked about a whole lot. There's a great summary that covers all that on page 775 of the text as far as the duties and liabilities of shareholders. That pretty much covers Chapter 40. 2 more segments left on chapters 41 and 42. Hope you're doing well, and hopefully we'll see you in class or on Zoom. Bollinger out.